Manever I say ma PENDREAM TV. PENDREAM TV there, osia dem yopo.
Some judge this time around went after the Chief Justice and outlined some of her behaviors that make him look biased and do things in favor of the President and Attorney General. Yes, you can see real things about the Chief Justice. And you can also figure out some things that know how the Chief Justice is behaving. In fact, she's working for the paymaster. And he also lets us know in some issues where the Chief Justice dictated to her. And I want you to join me listening to what he said into detail. Your comments are most welcome as well. Or you can send us a voice note on our WhatsApp number, which is 0277 128 777. Please subscribe to the channel if you are a new member. Share to all your friends on your contact list on WhatsApp or group members on WhatsApp, so that they can also have a feel of what is going on in the political arena. Stay tuned. You'll be right back. Thank you.
A match.
Yes.
And your reporter in the media are saying that anti-LGBT bill, Chief Justice has become an impediment in the wheels of justice, Sam George.
Yes.
This is a very, very serious allegation to make against the Chief Justice of the Republic.
Randy, let me say thank you first and foremost to the Ghana Police Service. They were very professional yesterday as we had the Family Values March, and to the tens of thousands of people who poured out on the streets yesterday. Clergymen, you had Muslim imams, you had Christian bishops, Bishop S.N. Mensah, Bishop Selassie, Genesari, Raymond Nakwa. I mean, a number of men of God, a constellation of men of God there. You had Numo Belinfo, and I was shocked. Numo Belinfo is very strong. He walked all the way with us.
So that's the match?
Yes. Okay. He walked all the way with us, from the start to the end. And Randy, it was just something else.
Where was the starting point?
We started from Obra Sport, went all the way to the Farisco traffic light. From Farisco, we took a 10, went through TUC all the way to the Law House. The Office of the Attorney General presented a petition there. And then from there, we continued all the way to the Supreme Court and ended up there. I mean, it was beautiful. My brother, Honorable Alassane Tuini, who is one of the signatories to the Family Values Bill, and Honorable Rita Odole-Sowa were also present. And it was
my MP.
Yes. I mean, she was there. She's also a signatory to the bill. You know, Arise Ghana was there, Concerned Drivers Association, the Advocates for Christ Coalition of Muslim Organizations Ghana, the National Coalition on Proper Human Sexual Rights and Family Values was also present. And Randy, we proceeded in a peaceful manner, but on the substantive
issue. Let me ask you.
Yes.
You took your matter to Parliament.
Yes.
This thing has gone on for well over 2 years.
3.5 years.
3.5 years. You took your matter to Parliament. The issue is ended up in the courts.
Yes.
Cease and desist. So he's now in the courts. What do you march for?
Okay. So
you're not patient enough to wait for the courts?
No, Randy, when the Chief Justice, as head of the panel, is actively working to frustrate the expeditious delivery of justice, we have a right as citizens to demand that she does her job. You see the way I've demanded of Chinia that he must do his job. It's the same way. Chinia is not different from the Chief Justice. He's paid, or myself. We are all paid by the taxpayers. And so we have a job to do. The Chief Justice has, this was supposed to happen on the 18th of September, and then it was postponed, on the 17th of September, then it was postponed to the 8th of October. On the 11th of September, the Chief Justice wrote to me explaining that it was not her fault and that's why the case has delayed. Randy, she's held 2 press conferences, issued 2 press statements, and written to me once. But that doesn't change our mind on the fact that the Chief Justice has the power to proceed with the case. There are 2 cases, and let me just explain this for the public. There are 2 cases before the court. The Richard Elaskai case and the Amanda Odoi case. And in both instances, you've got an injunction suit against Parliament and then the substantive case. that says that our bill is the bill that has been passed by Parliament is unconstitutional. The injunction is what is preventing Parliament from complying with Article 106, 6 and 7 of the Constitution to transmit the bill to the President. Now, that case has been fully heard. All submissions completed in the Supreme Court. In fact, a date of 17th July was given by the Chief Justice to pronounce judgment on the injunction case, so that Parliament can either proceed with transmitting it, or if the Supreme Court thinks that they are going to depart from their ruling in the Dafiamekpa versus the Attorney General, they would state that Parliament cannot transmit. The Chief Justice comes and says, well, we're not going to do that. We want to hear the whole case before we rule on the injunction case, effectively giving us an injunction, technically putting an injunction in place. She claims she's going to have an expedited trial. That's what she said. She said she'll have an expedited trial. Randy, it's been 10 weeks, 10 solid weeks since we finished that hearing on the 17th of July. There's been no indication, nothing whatsoever from the Attorney General or the Chief Justice. And now the Chief Justice writes to me and says that she's waiting for the Attorney General to file, and that even the plaintiffs have not necessarily filed all of their documentation. Randy, I'll give you two cases that show that the position of the Chief Justice is not entirely noble and correct. First and foremost, in the case of Roxanne Dafiamekpa versus the President or the Attorney General, where Roxanne went to court asking for an injunction to be placed on Parliament from hearing and approving the ministers for President Akufo-Addo. The case was filed by the lawyers. I'll just get you the date. But when the lawyer filed the case, the Chief Justice on that same day caused for them to send to the lawyers. The bailiff went to a lawyer, even with his absence, a notice for hearing the next day. So Roxanne's lawyer filed the case. The bailiff was sent that same day that the case was going to be heard the next day because it affected President Akufo-Addo. So the Chief Justice acted with expedition and immediately demanded that the next day they should come to court. When they went to court, the AG had not put in any defense. The Chief Justice heard the case that day and dismissed the case. Within 48 hours, in fact, 24 hours of filing, the AG had given a notice of hearing and dismissed the case. Again, when Bernard Ahiafo and two others from Parliament went to court and filed a suit against the Attorney General, once again, for granting of exemptions in Parliament, the Chief Justice ordered, they filed around 10 a.m., by 2 p.m., they had received a notice of hearing for the next day. When they went to court, in court, that was when the Attorney General brought his response. The Chief Justice asked him to serve a copy to the plaintiff's lawyer, Ahiafo's lawyer, in court. And the lawyer said, oh, my lord, if they've now brought me their defense, I will go and study it. She said, no, you have brought the case. You know what it is about. This is their response. Read it. I'm going I'm suspending the court for an hour. Read it. I'm coming back and make your argument. And she did that. Within an hour, she came back, forced the lawyer, and I don't want to mention the lawyers in these two cases, but forced the lawyer to read the case.
Why don't you want to mention that name?
Okay, I can. The first case was by the Nipapo Samoado, was the lawyer in the Roxanne case. In this particular case I'm talking about, where she asked him to sit in the court and read, was Samson Ladi Ayenini. Forced them to sit there and came back and dismissed the case. Again in 24 hours. So if the Chief Justice, when it affects President Akufo-Addo's government and the Attorney General is against the Attorney General, she's able to fix a notice of hearing same day. She's able to compel that the case should be heard the next day. And whether the Attorney General has filed or whether defendants have filed, she proceeds to hear the case and gives judgment. In this case, how is she telling us that the rules of court states that within 14 days of the filing of something you must respond? And 65 days on, the Attorney General has not responded. She says she's waiting for the Attorney General to respond. And Randy, I will be concerned as a sponsor of the bill at the attitude and actions of the Chief Justice on this matter when I take into cognizance the statements made by the Deputy Attorney General, what's her name? Diana Dapa, I think that's her name. At the Flagstaff House, when President Akufo-Addo met the clergy, the Deputy Attorney General told them to their face in front of President Akufo-Addo that this case, the clergy told President Akufo-Addo, look, let this case speak to the judiciary. They should place premium and expedite action. The Deputy Attorney General responding told them that the case will not be heard this year. Yes. The Deputy Attorney General, in the presence of the men of God there, the chairman of the Presby Church was there, the current chairman of GPCC, who is the head of the Church of Pentecost, Apostle Eric Nyamiche, was present. If I'm lying, they should come out and say I'm lying. They were in that meeting. The Deputy Attorney General looked them in the face and told them that this case will not be heard this year. So when the Chief Justice begins to act in the way she's acting, I have only one question. Does she work at the behest of the Attorney General and the Deputy Attorney General, or does she work for the people of Ghana? Because you see, Randy, another case after this Richard Delaska and Amanda Odoi case went to the same Supreme Court. That one, you know, our bill is based on Section 104 of the Criminal Offences Act, a natural carnal knowledge, and we expand the scope of it in our bill. So what they then did was to get a lecturer from Legon, Richard O'Brien crime, to go again to the Supreme Court to challenge Section 104. So that if Section 104 is deemed unconstitutional, then our bill is even dead on arrival. Now that panel was headed by Justice Abdullahi Tanko, had Justice Yoni Kolendi on the bench. Randy, during the legal vacation, they heard the case and gave a judgment, issued a 59-page judgment. In fact, Justice Abdullahi Tanko gave his ruling. Justice Yoni Kolendi wrote a quorum judgment in agreement, where they struck it out and said that Ghana Supreme Court will not be peer pressured by foreign influences to accept homosexuality in any shape, form, or opinion, and that it is not welcome and will not be entertained by the court. This is the position of her brothers on the bench at the Supreme Court, Justice Abdullahi Tanko and Justice Yoni Kolendi. God bless them. We want to find out from the Chief Justice of Ghana, Madam Gertrude Tokono, does she disagree with her brothers on the bench? By virtue of the ruling of the same Supreme Court in the Richard O'Brien crime case, the Chief Justice has no business continuing with this case because it's the same case. Except she disagrees with her brothers. She has, I mean...
So what did your petition contain? What do you want her to do?
Simple. We gave her 14 days to give us a timetable.
14 days?
Yes, within 14 days we want a timetable from the Supreme Court. They must give us, she herself, I didn't put a gun to her head. She herself said in court on the 17th of July that we will have an expedited trial. So, or expedited hearing of the case. She must give us the timetable for that expedited hearing because 10 weeks on, I know the wheels of justice grind slow, but for them not to have moved an inch in 10 weeks, it means there's a cog in the wheel. And that cog currently is the person who has to give us a timetable, the Chief Justice. She must give us a timetable.
And you're saying that although the judiciary is telling us that the delay as far as the case is concerned has to do with the parties in the case, not the bench, you disagree and give examples of why you disagree. So you believe that even if the parties were delaying in the matter, there is enough precedence to suggest that the CJ could still go ahead and do something.
Absolutely. I'll give you a third example. The Supreme Court, the election petition hearings. The Supreme Court gave a timetable. And lawyers had to keep to that timetable and do their fight. There were several times lawyers for the plaintiff, Judge Chikanko, even had to beg the courts for an extra day to be able to file certain documents. The court said, no, we are sticking to our timetable. So the Chief Justice has the power. But Randy, we hold the considered view that the Chief Justice is acting under the influence of the statements made by the Deputy Attorney General, and she's seeking to please them. And that's why she's delaying the process.
So in 14 days,
yes,
if you don't, you're asking for a timetable.
Yes, give us a timetable that states
which will
how she
demonstrate an expedited hearing.
Yes, based on what she
promised. And if you don't, her position or the position of the judiciary has been made clear that look, the ball is not in our court; it's in the court of the parties in the matter, and they accuse both sides, both Parliament and the Attorney General, of not complying or not fulfilling their responsibilities as far as this thing is concerned. Now, if in 14 days you don't have what you're asking for, what will happen?
We'll take on the next step.
Which will be?
Randy,
you won't tell us?
No. Because we'll come there. Because you see, as soon as I mentioned that we're going to do this match, the Chief Justice started issuing press statements. In fact, the last press conference they did, they claimed that maybe on the 15th of this month, they are open to a hearing and all. We want a comprehensive timetable.
15th of this month is Wednesday.
Yes, we want a comprehensive timetable. They should stop responding to us.
Are you going to dictate to the judiciary how to go by their work?
No. We're not dictating. We're pointing out to the judiciary what appears to be apparent double standards in their actions. And we're asking the judiciary to absolve itself of the perception that they become an appendage of the Attorney General's department. And that the Chief Justice is taking directions from the Deputy Attorney General. She must fight actively that perception. But if she continues in her line of action, she lends credence to the fact that today our CJ is taking directions from the Attorney General.
All right, okay. Let me bring Chine in. Chine, have you been following this matter?
Yes.
Okay. Yes. But can I ask yes. Let me say thank you to Chinia.
For what?
He was one of the 275 MPs in Parliament who supported us and passed the bill. Because I know he doesn't. I know Chinia's preferences. I mean, he doesn't support homosexuality. So, my brother, thank you so much for. I mean, putting partisan politics aside and the future of our children. And you were part of 275.
Do you feel patronized?
Why are you saying all?
No, but you were part of the people who
passed the bill. Do you feel patronized?
Or you've changed your mind?
Sam George.
Chinia, do you feel patronized?
Anyway, Randy.
Yes.
I mean,
Hof Chinia.
So,
I'm calling you Hof Chinia because that's what's on your shirt.
Oh, stop that. Stop being mischievous.
Hof Amidu.
All right, Chinia, let's hear you. Ignore him.
So let me say good morning to the people of Sisala East.
Right.
And then everybody listening to us this morning. I mean, the matter of the anti-gay bill is very, very important to all of us, every citizen of Ghana, because today we are here because, I mean, our fathers and mothers got married. If my father had not married my mother, I don't think that I'll be here today. So in order to promote procreation, we have to promote men marrying women and nothing else. That is in accord with our traditions and our religious beliefs. I mean, I have said before that I have never come across anybody in my constituency, the constituency I represent in Parliament, in favor of homosexuality. And so I have no business supporting, homosexuality. So, like he said, I mean, I have been all out for supporting the bill to ensure that we promote our culture, our traditions, and our religious beliefs. Now, my only disagreement with him is the way he's taking on the Chief Justice and the judiciary. And that is becoming of the NDC, because when there is ruling at the court in their favor, they celebrate the court, they celebrate the bench. But when things go in a way that doesn't look favorable to them, they find every reason to make the people look bad. And you see, in a democracy, the courts are there for all of us. And we can only continue to add value to what they do. But the way we add the value to what they do so that they become an excellent institution that promotes our democracy should be in such a way that we don't undermine them, we don't insult them, we don't antagonize them unnecessarily like Honorable Sam George is doing. I mean, it's full attack on the Chief Justice. that I think is unfair, because the registrar to the court, or is it, they have made a case that the plaintiffs in the case, which is Richard Delesky and Dr. Amanda, they are the plaintiff in this particular case, have not filed the necessary documentation. The defendant, which is Parliament and then the AG, have not also filed. So if you're a judge and the case is brought before you, and the plaintiff doesn't file the required documents that he needs to put before the court, the defendant does not do that. On what basis do you proceed? On what basis do you proceed? The one who has come to make a complaint before the court has not filed necessary documentation. The one who is supposed to defend, or who is being accused, in this case, Parliament, the Speaker, represented by Tadia Sori, and then the AG, they have not filed their documents. So the court is limited to proceed. They can never proceed. And so some judge who you have just told us here that you have done LLB, and you know that if the parties in a matter before a court don't put their case before the court can proceed. And in this case, the plaintiff, the defendants, have not put before the court the required documentation for the case to continue. So how is the Chief Justice or the Supreme Court supposed to proceed?
Can I ask you a question?
Yes.
On basis of this. So there is something novel about this case. Mm-hmm. And what is novel about this case is that at the heart of this matter, apart from the issue of a constitutional interpretation, is also a rift between the executive and the legislature, and the issue of whether the executive can even prevent Parliament from doing its work, because that's a contention of Parliament, really. Now, there is an application for an injunction, or there's in fact an injunction on the executive. Now, the executive also relies on this particular matter, to justify why it is preventing Parliament from doing its work. Now, the Chief Justice decides that although the injunction was filed separately from the substantive matter, she will put the two together, because the injunction matter was before her. The injunction matter has been fully heard. All things have been filed. The arguments and everything has been made. And it was left for her to make a pronunciation on the matter. And she says that, because that would have then determined whether indeed the courts were going to allow for an injunction or otherwise. She says, no. Instead of giving you the decision on this one, I want to add it to the substantive matter. So she does that. Now, she says that the parties in the matter are the source of delay as far as the substantive matter is concerned. So, on the basis of that, the injunction is pending. And she decided she could have given the decision on the panel could have given the decision on the injunction because it was separate. But it was her decision to put the two together. Now, we're saying that this thing is stalling, and you now have this tango between the executive and the legislature. Are we saying that at this stage, the court can be stopped or dissuaded from going ahead to do its job because the parties in the matter have decided that they will not show the kind of interest that they should show on the issue?
Well, Randy, I think that in the case of the injunction, I have a personal opinion. And my personal opinion is that I don't think that it was out of place if the presidency had even accepted the transmission of the bill from Parliament and then write to Parliament that because of the substantive case pending before the court, will wait to see the outcome before the president can act. So the presidency could have accepted the bill, which would have not been necessary for the injunction to be in the court in the first place, because a parliament is aware of a matter in court and decides to proceed to pass a legislation, and then it goes to the president, and the president has issue with the matter being pending in a court, then the president could just write to parliament that, yes, I have received the bill transmitted to me, but from my perspective, because there is a contention in court, I will wait for the outcome of the court decision. Then I'll proceed from there, so that my decision that does not interfere with the court decision. That is how I think it should have been. That is my personal opinion. So that the substantive case should be the most important thing. As for injunction and all those things, for me, they shouldn't have arisen in the first place, because the presidency could have accepted the bill from parliament.
But this is where we find ourselves.
So. I mean, and on the other hand,
the decision
of the Chief Justice is her decision.
Yes.
I wouldn't want to go into it whether she's right or wrong, but I thought that.
No, my point is that I don't think, I've not heard anybody raise a legal point. I have not heard anybody raise a legal point with respect to the legality or otherwise of a decision to put the two together. But I'm saying that to the extent that the cases were filed separately and the decision of whether to grant the injunction or not had an impact on the umpires, and that she decided that although this was filed separately and all the processes had been dealt with awaiting my decision, I have decided that I'll add it to the substantive matter because I think that it will enrich the process.
Well, Randy, to be fair to the issues, I think that the two must be treated separately. If the injunction case has been heard, and I don't know the facts.
It was left for the decision. Yes.
If it's left for a decision, and the substantive case, the parties involved have not filed the necessary documentation for hearing to proceed, then I will say that it would have been good if a pronouncement was given on the injunction, separated from the substantive matter. But I don't know her reason.
Or if that's why I said, or if there was sound legal reasoning, and I believe that that may be the case of putting the two together.
Yes.
Then she should have ensured that the parties will expeditiously do what they have to do. Or otherwise, she would then give some new directives on what to do.
Yeah, I think I agree with you on that score, because once hearing is completed on the injunction matter, everybody expects a ruling to be given. So if there is any reason for it to be added to the substantive case, then steps should have been taken to make sure that the parties file the necessary documentation for the hearing to take place, so that you can make a pronouncement on both cases. If the parties are not cooperating, then probably they could have changed their position to give a judgment on the matter that has ended, pending a decision, and then now continue with the substantive matter. But as far as the substantive matter is concerned, that is why I disagree with Sam George, because if the parties involved have not filed their documentation, the court cannot proceed. The court can only throw out the matter, but I don't know the legal effect it will have if both parties, that is the complainant or the plaintiff and the defendants, have all decided to stay away from the case, refuse to file necessary documentation.
But if you bring your matter before court and it appears that you are disinterested in the court, in the matter that you brought, what should the court do?
But the interesting part is that even the lawyer for parliament has even filed for request. That was what Honorable Sam George was referring to, the 15th to 17th hearing that they are talking of. It's a case filed by the lawyer for parliament to ask for extension for him to file his documentation.
Okay.
And so all this, is contributing to the delay. And he is supposed to...
But many times we've seen the court step in and say that, look, you are unnecessarily or unduly delaying this matter.
Yeah. So probably the court should intervene and get the parties to file. But what I don't like is the way my brother is trying to, put some very bad light on them. Let's appreciate the work they do. We can disagree with them, but we have to be a bit polite and a bit sensitive to the job they do. They're serving Mother Ghana, they're serving all of us. In some instances, you find that the work they do is satisfy us. In some instances, too, we disagree with them. But when we even disagree with them, we have to be polite, and we should not create scenarios to make them look so bad, like Honorable Sam tried doing.
Right.
Randy, let me say that Chine has done a good job of positioning the whole situation, and maybe he'll do a better job advising the president on things like this than they're doing at sanitation at the moment. But you see, you know why the president would not take your advice and have accepted, which is the right thing to have done, is because the president could not have accepted the bill and then turned around to say that because it's in court, because the case is in court, he can't respond. Because the president himself had set up, the president said with the e-levy, it was in court, yet the president went ahead to sign the bill, the e-levy into law, without regards for the court. So the president himself knows that he set a precedence where courts, something being in court, does not stop him from signing. And that's what he did with the e-levy. And that's why the president will not take your advice. Again, I agree with you, and that's the point we're making. That today, if we have an impasse between the executive and the legislature, it's because the Chief Justice, as head of the panel, decided to join the substantive case to the injunction. So the excuse they are giving today of documents not being filed is a problem created by the Chief Justice herself. But you see, Randy, we have the greatest of respect for the courts of the land. From Circuit Court all the way to the Supreme Court, we have the greatest of respect for them. But our respect for them does not prevent us from letting them know when they get it wrong and when they are going out astray. And that's why I'm drawing the attention of the Chief Justice. Maybe she's not aware. You see, she's not aware the perception out there about her on this case and the courts on this case. Maybe she's not aware that the Deputy Attorney General has told heads of churches that this case will not be heard this year. And so when it appears as though her action is matching the directive given by the Deputy Attorney General, we need to call her out and let her know that, Madam, you need to be mindful, because the perception out there is that you are trying to fulfill the wishes of the Deputy Attorney General, which should not be the case. The courts ought to be independent. They ought to. Even if they are not, they should give us a semblance of independence. And I've given you typical examples, 3 on this platform, of how the courts have acted when the foot is the shoes on the other foot. We're only asking for a timetable for expeditious hearing. If the people, and like Randy rightly said, if she had a good reason for joining the cases, and now both plaintiff and defendants are not living up to the billing and slowing down the process, it's within her rights to say, okay, I'm dealing with the injunction which is done, because that part is done, it's completed.
All right, okay. Let's take a break. When we return. Yes.
I was just asking Honorable Sam Joy, this matter of the Deputy AG making that statement.
Yes.
Do you have any evidence to that effect?
I have mentioned the names of, I haven't mentioned any small people. The Church of Pentecost has almost 5 million members. They are the biggest Pentecostal church in Ghana. And I'm saying to you that the head of the Church of Pentecost was in that meeting. Apostle Reverend Dr. Eric Nyamiche, I'm saying to you that the head of the Methodist Church was in that meeting. And there's several other people. You know, I'm giving this.
You are just mentioning names, but there's no evidence enough. There's no evidence enough.
Listen, Randy, as sponsors of the bill, we worked with the coalition.
I know.
The National Coalition on Proper Human Sexual Rights. So when that...
Because you were not in the meeting.
Oh, wait.
And somebody could just make an allegation to you. That may not be right because you were not in the meeting.
That coalition is headed by a former chairman of the Church of Pentecost, Apostle Opoko-Nyina. And I'm saying to you that when the coalition was invited to the meeting, I was aware. The coalition went. After that meeting, the coalition came with a report. It wasn't one person who came to report on the issues that went on and the things that were said in that meeting. And I'm saying to you, that's why I didn't say the Attorney General. And there are 2 Deputy Attorney Generals. I'm specific on who it was that was in that meeting. And I'm telling you what she said. And look, Randy, this is a big platform. If the Deputy Attorney General says that what I'm saying is a lie, she has the right to a rejoinder.
All right. Okay.
You can't afford to miss out a lot on PENDREAM TV. For that matter, I'll urge you to stay glued to it by subscribing to the channel as a new member, hitting the notification bell to alert you of any post that you will make or upload onto the channel. Please don't mix out. We have a lot coming your way, and this is the best channel to receive any latest updates on politics. Thank you for staying tuned as well.
Dedi kama mamena PENDREAM TV ase. Na so far so good. Say open online portal e wo Ghana. Nipa share, nipa follow, nipa comment here. To my best of knowledge, without any biases, PENDREAM TV.